Hello, I'm Charles Christian, and today we're going to be talking about e-billing, and particularly how e-billing has evolved, now becoming a fundamental part of the whole law firm to corporate legal department relationship. We'll also be comparing and contrasting experiences in the UK and in the US. With me today I've got Martin English. He qualified as a solicitor, previously having worked in technology, and he's now head of sales for Serengeti in the UK EMEA region. Next to Martin we have Julia Chain. Julia is the former general counsel of T-Mobile, where she was there for 8 years, and for the last 10 years has been working as a management consultant, primarily to the in-house legal world, advising corporates on such things as spend management and panel management with their law firms. And finally, over from the United States, we have Rob Chattel. Rob heads up sales for Serengeti in the US, and he's been working with Thomson Reuters and their in-house legal clients for the best part of 17 years. Let's start off with a very basic question as to what is e-billing, because it means different things to different people. You see lots of talks about things like LEADS and UTBMS, and on the other hand you have people saying, well, I send a PDF of my bill with an email. That's e-billing, surely.
E-billing describes a data-driven transfer of an invoice or a bill from a law firm to its corporate client.
If I can just add to that, it's very much about a collaboration piece for in-house counsel to work better and more efficiently with external counsel, and it's very much about a transfer of data. I quite often talk to GCs about e-billing, and yet we've got e-billing, we have a PDF, and we say, well, that's, in our world, that's not really e-billing, that's a picture of your fee note. So e-billing in our world is very much getting access to that underlying data.
E-billing's been around for best part of 20 years. How is it evolving in the US? What's the experience? We've talked about what it is now. Has it moved on beyond being just an administrative sort of overhead?
I think it absolutely has. I think that as the e-billing capabilities have improved and as time has gone on, I think corporate legal departments become hungrier and hungrier for the data that can be derived from e-bills. So where e-bills in the beginning were just a way to transfer the bill and review and approve the bill, now it's much more than that. The data is now able to be extracted. Systems are much more powerful to be able to analyze and provide things like benchmarking and peer comparisons and very sophisticated reporting that can extract that data and provide it to the corporate legal team in order to make data-driven decisions.
When you're talking of benchmarking, this would be what, a in-house legal team reviewing the performance of the various law firms on their panel?
The performance of the various law firms as well as their own performance. For example, what's the average rate we pay our law firm for litigation work or IP, patent prosecution versus our peer group? And a peer group could be companies in my same industry, could be companies of similar size, legal departments of similar size. It also could be, how am I doing as a legal department? One thing is rates and performance of the law firms, but let's say, what's my experience? How much do I pay? What's my total spend for litigation versus peer group? Are we heavier litigation or lighter litigation? Do we have more in employment legal costs than the average corporation? That may not indicate my law firm's performance. It could indicate that I have an in-house legal department, need to do a better job of managing, for example, my employment experiences.
Building on what Rob says, it has even wider implications for making a very positive contribution to information within a company in general outside the legal department. And just building on what you say about employment, if you notice that throughout the organization suddenly there's a a huge increase in the number of compromise agreements, for example, employment termination agreements that have suddenly come up. You know, you can get that data, and that might tell you that actually in this department or that department in the business there's something a little bit wrong about that. Or for example, there's an increase in the number of claims in a particular area. You can use the e-billing and associated matter management functionality to give you that data, and that actually can very much help strategically within the business to manage the business. So I would think and say that this is actually something that goes well beyond the remit of the in-house legal department or just managing, you know, law firm spend copying charges. It's actually, if you use it properly, a very neat strategic tool to help the business manage itself.
Just to that point, the conversations that I'm having time and time again it's on the data. That's what GCs are really turning on to and seeing the real benefit of an e-billing type solution, matter management solution, is that pass-through of data and being able to really unlock the value that can be derived from the legal department. And it's very much about them being able to run their department just like any other business unit. So there's a lot of value and a lot of power behind e-billing. So as I said, it transcends.
Are we seeing, Julia, from what you've drawn from your management consultancy experience, are we seeing a change in the nature of GCs now, from being the in-house lawyer to being more of a strategic business manager?
Yeah, I think so. I mean, this was always the case in the United States for many years now. But I think really over the last 10 years or so, that change has been dramatic in the way that businesses view their in-house teams and in the role of general counsel. And I think it's interesting to note that now we've sort of gone past the stage of saying, well, the general counsel needs to be part of the business community, he or she needs to be part of the board or at the board, the in-house department adds value. I think that's sort of a given, and therefore the general counsel and the in-house team have to act differently because actually their role is different, and it's now recognised their role is different. And that's far more about adding value, adding strategic value, managing costs, and also in a very difficult environment of risk and regulation, really managing risk for the company. It's becoming a very big area, particularly where there's personal liability in the way that there probably wasn't many years ago. All this means that actually the day-to-day has to be done somewhere else, or has to be done more efficiently and automated, and that data and the management of data becomes a key tool in the sort of arsenal of what the GC has to offer.
Isn't there also a change in the way corporates are now looking to reduce the number of firms they use and generally consolidate?
Yeah, I think, it used to be, particularly with banks and the larger larger in-house legal departments, that it was accepted that you could have a roster of 200 or 300 law firms. Normally you didn't use half of them, but either they were clients of, say, a bank, or somebody played golf with somebody important, and that's how it all worked. I think those days are maybe not quite gone, but they're going. And most GCs are looking to reduce that number to a small number of firms where sort of horses for courses, if I can use that phrase. So you've got the 2 or 3 law firms who are really partnering in a very meaningful way with the in-house department, and that relationship is built on all sorts of interdependence, so not only providing legal advice but providing training or helping one way or another, and then a whole set of relationships which are maybe not partnership but are being used for specific things. So commodity law firms, this is the law firm I use when I've got just churn over work, fixed price, let's just get it done. This is the law firm I use for large transactions. This is the law firm I use for whatever. So it's very much about deciding what's going to add value and creating a panoply, a suite, if you like, of relationships rather than one size fits all.
And I think that very much talks to the power to the buy side now, isn't it? And law firms should not be scared of this technology. It's, to your point, Julie, about adding value. law firms have got to add value now, even more so than they have done in the past. And before I came into the law, I was in the technology sector, and back in 2000, 2001, it was very much more for less. And I'm seeing that mantra very much in the legal profession now. And law firms have to go that extra step beyond. They've got to demonstrate value, and they should not be scared of this technology, because it's a cliche, but it should be a win-win situation.
I mean, I can give you a real example, a real life example. I did a project with a bank a year ago, where there was several £100 million of spend and many employees in the in-house legal department. And we worked for probably 6 months to identify, to really analyse their spend, identify exactly as you said who was doing what the associates were doing, how much was spent on this and that and so on, and produced a really nice little report. That took 6 months of very expensive consultant time. They then got e-billing, and all that information now comes to them on a daily basis, because you've put the frameworks in to get the information and so on. So it's very easy to do, and actually it's something that in a manual environment you never quite get to the bottom of, and is actually quite time consuming and difficult to do.
There's always been a perception that the European market has lagged behind in terms of e-billing, maybe a few years time lag. Why do you think that is, and if it really does happen, and what's been done to change it, and is it evolving, is it changing now? Do you want to come in, Julia, with your experiences when you were at the sharp end there?
Firstly, I agree that we in the UK, and perhaps one might say cautiously even more in Europe, are lagging behind the US in this. I think we're catching up, but I think it goes to the root of the fact that it took some years before the role of the GC and the in-house counsel had the same prominence and respect, if you like, that it had in the States. So the job was very different. That job, as we said earlier in this conversation, has now changed, and therefore the in-house legal departments need increasingly sophisticated tools in a way that perhaps they didn't. I think also the type of work they're doing requires them to have far more data and be far more, if you like, at the sharp end of what a business is doing. And also, finally, to Rob's point, there's less, I wouldn't say respect, but there's less nervousness about challenging law firms and holding them to account. And also there's far more choice in the sort of law firms that an in-house counsel might go to. I mean, it used to be that for a large transaction, if you went anywhere outside a major city firm, people would think, you're sort of smoking something. Why would you ever do that? And now it's routine to, as I said, talk about horses for courses, to use different sorts of firms, maybe to outsource altogether. And all these different arrangements need data-driven solutions.
Don't you think also there's been a misconception about what a system like this does, that it's about strong-arming the firms and arbitrarily knocking down bills? And don't you think that tide is turning about that? Because it's not about that, it's about collaborating.
It is, and that's very much what I say in the conversation I'm having. It's not about beating your law firms up. It's not a stick, it's a way of working better. And to your point, Julia, I completely agree. We have a generation now coming through who are used to social media, researching the law in different ways, and are tech savvy. And they're happy to work in this manner, and they fully embrace it. And they want to go to their boards and say, look, here's a technological solution to completely transform how we as a business can operate.
And it creates partnerships. I mean, the biggest change, I think, in the relationship between law firm and in-house is your point, Rob, that instead of being, we are a service provider, we are the law firm, you will do what we say and so on, it's an equal partnership relationship with actually the partner and the associates in the law firm very much respecting the expertise of the in-house lawyers and feeling that actually we're all on the same level, which I would venture to say probably wasn't the case 10 or 15 years ago. Now it is. We're all professionals, we're all collaborating, we're all on the same level, and therefore the relationship itself is very different. So this isn't, as you said, a stick to beat anyone. It's actually a collaborative tool and can be used that way.
And I'm seeing that in the United States, to your point, the partnership, the working together, where a conversation at the outset of a matter is occurring, not just about billing, but about who is doing what tasks as it relates to a project. if it's litigation, the in-house attorneys are taking a much more active role about actually doing the work that at one time maybe was exclusively done by the outside counsel. Even as preparing for and executing filings in a court case, much of that work is now shared, but there's an active discussion going on that's then documented in the system about who's going to do what, who's responsible for which aspects of the case or the matter.
Right, thank you very much. That's really very interesting. So to sum up, we've seen how e-billing has evolved from being primarily administrative function, an invoicing function, to now being a fairly fundamental part of the whole law firm to corporate counsel relationship. And far from being something that law firms should be frightened of, it's actually going to enhance and probably strengthen their relationships with their corporate clients. I hope you've enjoyed this program. Thank you very much for watching.